Hello friends. Today we're going to discuss about evaluation of child custody cases. I'm Dr. Suresh Bada, Professor of Psychiatry, working at NIMANS, Bangalore. Before I start my presentation, I would like to place this disclaimer. This presentation is for academic and training purpose only. This is not a substitute for professional legal opinion. For legal opinion, please do contact an advocate. Conflict of interest? None. In this video, I'm going to discuss about the evaluation of child custody and how a mental health professional should assist the court in deciding the child custody. This video is targeted to doctors, psychiatrists, mental health professionals, advocates, judges, and counselors. Let's define child custody evaluation. Child custody evaluation is a process in which the evaluator will gather the information from all stakeholders, that is, child, parents, in-laws, aunt, uncle, and he will study the environment of the child. Once he has done the evaluation, he will interpret the information and make a recommendation to the court based on the best interest principle of the child. That means his decision should be child-centric, not the parent-centric. And that needs to be kept in mind. In an ideal scenario, both the parents should sit together and decide about the child custody. That is very important. If they are unable to come to a conclusion, they need to take help from the mental health professionals, such as psychiatrist, psychologist, or a social worker. Based upon their recommendation, they need to implement that. In spite of their recommendation, they are unable to come to any conclusion. Invariably, they will go to the court. The court may give the opinion based on their wisdom, or else they may even ask for the evaluation by the mental health professionals. Now let's discuss what are those factors which play a crucial role in child custody cases. First and the foremost, the factor which has been found to play a major role across research studies is substance abuse in parents. If one of the parent is using substance that is harmful to the child, hence, across the world, the court has given the custody of the child to the parent who is not using substance. That is number one. The second important factor is parenting skills. Who has the better parenting skills, mother or father? Based upon that, the second important factor which plays a role. Third one is parental attempts of alienation of the other parent, that is, parental alienation syndrome. If one parent is trying to brainwash the child against the other parent, that is a factor which goes against that parent. That means the parent who is trying to alienate is called as alienator. He will not be given the custody of the child. The fourth one, the nature and quality of the child's emotional relationship with which parent is very high. If the child's emotional attachment is with the mother, invariably the mother will get the custody of the child. The emotional or psychological stability of each parent. Imagine if one of the parent is highly impulsive, aggressive, and also very angry. In such a scenario, he may not get the custody of the child. So, emotional and psychological stability is very essential. Fifth important point, each parent's openness towards child's contact with the other parent. That means that parent should not have parental alienation syndrome. That is the sixth important point. Seventh, the parent's history of compliance with the court. If the child custody case is going on in the district court and in the high court, how does one parent behaves in front of the court? Whether he is compliant to the court's order or not. Eighth, the parent's pre-separation, caretaking and parenting role. Before the marital discord or before the case of divorce comes in, what was the role played by the father, the mother? What were their parenting skills? How did they caretake the child? How did they play a responsible role? That's also play an important role. The next, the stated preference of the child. If the child is between 5 to 17 or 18, if the child is able to say, I would like to stay with my father, and it is able to give a logical explanation regarding the preference of one parent over the other, the court may consider the child's request. Further, the parents expressed anger or bitterness regarding the divorce in front of the child against the other parent also will be taken into consideration. Further, parents' physical and mental health. If one of the parent is having disability or else mental health issue, invariably that will come in the growth of child's health. Hence, the person who is healthy will be given the custody of the child. Economic and job stability also plays a very crucial role. Further, significant support from the others. That may be in-laws or else father's parents or mother's parents. All those also will play an important role in the child custody case. Further, if there was domestic violence, dowry harassment case, arrest of in-laws, husband, criminal case against one of the spouse, also play a crucial role in child custody. Further, material and economic influences of the parents also has been considered in certain decision. These are the 15 important factors which play a crucial role in child custody cases. Now let's discuss about the impact of conflict or the divorce on children. There are tons of literature which clearly says whenever there is a divorce or a parental conflict, the child will have enormous mental health impact. The child will suffer from depression, anxiety, alcohol and drug abuse, suicidal ideation, suicidal attempt, death by suicide, social problems like isolating from the public, aggressive behavior, deliberate self-harm. All these are known to happen in children. It is not only short-term, even long-term impact on mental health condition of the children do occur. There are studies which have been shown beyond doubt that mental health of the children is impacted during separation, divorce, or during the custodial dispute. And also the studies clearly says that divorce runs in family. For example, the studies clearly said daughters of the divorced parents have 60% divorce rate if they are married, if they are going to get married, while sons will have 35% divorce rate. That means divorce runs in family. Both environmental factor, genetic factor and combination of both plays a important role. There are many studies which are being studied with regard to meta-analysis, with regard to genetical studies, with regard to environmental factors, depending upon what type of relationship the child and the parent has. Based on this, these divorce running intergeneration has been studied very well. Moving to another important is parental alienation syndrome. This parental alienation syndrome arises primarily in the context of child custody dispute. Here, one parent is going to program the child against the other parent, and that programming is beyond the logical explanation of the child. The child will mirror the emotions, thoughts of the alienator parent. But however, the court will consider the best interest and welfare of the child during the child custody cases. That means, although India is known for various laws based on personal laws, based upon the religion, based upon the secular laws, however, now the courts have evolved to decide the child custody cases based upon the best interest principle, that is, welfare of the child is prime, importance is given. Let's discuss about this best interest and welfare of the child. Welfare of the child is considered as very important, and cases of child custody cannot be decided solely by interpreting the legal provisions, because it is a human problem and it is required to be solved with the human touch. The Supreme Court has told in many cases. That means you are not just taking decision based upon the rules, laws available. It should be in the best interest of the child. Now the question is, what is the best interest and welfare of the child? What does it mean? Best interest means it is the whoever has the best economy, whether the father has money or the mother has money. Is it the education of the father or the mother? Whether the intellectual capacity of the father or mother? Is it the comfort? Is it the health of the father or mother? Is it the society? From which society the father is coming or the mother is coming? Is it the background of the family? Abuse? Culture of the family? Father's family's culture or the mother's family culture? Religion? Personality of the father or the mother? Content with regard to the life? Spiritual growth? Or the morality, environment and ethics? What do we need to consider when we say best interest of the child? Whether the father's family has these important ingredients or the mother's side has these important ingredients, and which of this is very essential, that needs to be understood, because the best interest principle becomes very difficult to define unless we know what does it mean. Then only the custody of the child can be easily decided. So the best interest of the child, it is the psychological well-being of the child is dependent upon parents' physical and mental health, whether the parent is using drugs, substances, and if they are using, that means it is detrimental to the child custody, whether one of the parent is spouse friendly, there is no parental alienation syndrome attempt, parenting skills of the parent, time devoted for the child before the divorce and after the divorce, family environment, child's wish, economic stability and job stability are considered in decision of child custody cases. Let's understand what are the evidences which needs to be there in the assessment. The research clearly indicates children do better in environments where the parental conflict is very minimal or it is contained between the father and mother. That means, although there is a marital discord, the child is not dragged into the divorce case or in the child dispute case. If children maintain a good relationship at least with one of the parent, if it is both the parent, that means the impact of the parental conflict or the divorce will be very minimal on the child. Further, no physical or mental health issues in the custodial parent plays a very crucial role. That means the court needs to ask for a mental health evaluation of the parent. If the parent is very healthy and psychologically very good, physically very good, that means he is going to play a major role in taking care of the child. Let's understand the claim of custody. Who can ask for the custody of the child? It is usually between the father and mother. Sometimes, if the father or mother is missing, in such a scenario, grandparents of the child or the in-laws, paternal uncle, paternal aunt or maternal uncle or aunt can ask for the custody of the child through the court. During the evaluation of child custody, the information need to be collected from multiple agencies. First and the foremost, legal related information. What was the need for divorce? And why the divorce case was taken place? Child related information, parental related information, family related background, and school related information need to be collected. In this background, let's understand what is the role of mental health professionals in child custody cases. The mental health professionals play a crucial role with regard to evaluation of the child mental health and also the impact of parental conflict on the children. As I said earlier, during divorce, the children go through enormous stress and also mental health issues. That is very essential. Second one is evaluating the parental mental health is also essential. Third, evaluation for parental alienation syndrome. Clinical interview of the child, clinical interview of the parents. And the mental health professionals need to observe the child-parent interaction. Interaction between the father and the child, mother and the child, family as a unit. Family visit and school visit, if required, needs to be done. And also, the mental health professional need to take information from other significant evaluation. It may be family environment, talking to the teachers, talking to the paternal aunt, maternal aunt, based on all other information. And the mental health professional needs to give recommendation keeping the best interest principle of the child. Now, let's understand the referral for evaluation. The referring authority can be court, which is common in India, or else the parents may come by themselves, or one of the parent may bring for evaluation, or else other significant may be in-laws, grandparents can bring the child for evaluation. So before you start the evaluation, know who has brought the child. What was the reason for the evaluation? Please document it. If the court has referred, please document the referral letter. Keep the copy of that letter along with the medical records. Now, let's move into the assessment of child custody evaluation. What is the duration required for evaluation? The evaluation can be occurring either inpatient or outpatient basis. It is left to the professional discretion. Either it can be done inpatient or on the outpatient. If the mental health professional like psychiatrist is very good qualified, had amazing experience with regard to child custody case, he can do on OP basis. Invariably, we need to do this assessment in the hospital. Many a time, the counselors, psychologists do this assessment in park, maybe in the school. I would request them not to do that. In such a scenario, the child will be distracted, especially in school, especially in parks. Hence, the hospital will be the neutral place to do this assessment. And again, I say, avoid this assessment in non-hospital setting. Further, the duration required for assessment will be invariably between somewhere around 18 to 26 sessions. So, IP basis assessment will take somewhere around 4 to 6 weeks, whereas outpatient basis assessment will require 12 to 21 weeks. I have seen many of the psychologists, social worker and psychiatrists giving the evaluation report in 2 or 3 sessions. In 2 or 3 sessions, you are not doing any assessment. You are doing injustice for the assessment. Invariably, you will be giving a wrong recommendation. If you look at the Western literature, they clearly says at least 12 to 21 sessions is required before you do the recommendation. And each session will last somewhere between 45 minutes to 90 minutes. And also session should occur 1 to 2 sessions per week. And session may be more depending upon the mental health issues of the child and the parents. So you need to understand this. Doing assessment in 1 or 2 sessions is not going to help the child. And you're not going to assist the court. You'll be misleading the court. Hence, my sincere request is at least have around 12 to 15 sessions to do a good job. Now, during the assessment, what are the collating information and clinical assessment one need to do? First and the foremost, if there was a divorce, please take the divorce decree, a copy of it. If possible, whatever the application given for divorce, both from the husband side and the wife side, needs to be taken, because you will be knowing the background of the case. And also child custody papers, court referral letters. If there are any first investigation report, FIR, domestic violence report is there, please collect them. Divorce applications, decrees, if it is there, please collect that. Get the school reports, teachers report or academic reports. If there are any medical disability or medical related illness or mental health illnesses, either the child or the parents need to be inquired, and if you are able to get that, it will be helping you to make decision and recommendation. And now you need to do stakeholders interview of the child, parents and grandparents. Now let's move into the clinical assessment. First and the foremost, you need to do the clinical assessment of the child, whether the child is suffering from any mental illness or not. That invariably occurs if the parents are going through divorce or else the divorce has occurred. Clinical assessment of the parents. Any of the parent having drug abuse, alcohol abuse, or any other mental health issues need to be assessed. Child-parent interaction has to occur, and you need to observe them. How does the mother interacts with the child? What is the behavior of the child with the mother? How the parent, that is the father and the child interaction, that needs to be observed. Interviewing the third parties like friends, relatives, aunt, uncle, to gain a better understanding of the children and their parents. And now move towards the psychological testing after doing all these things. Psychological testing of the parents, psychological testing of the child or the children, family assessment of the origin of the father and also the mother, and also the family of procreation need to be assessed. If required, visiting the child's home or the school needs to be done. Now let's move into psychological testing. What are those psychological testing which needs to be done? Invariably, many studies have reported that they are using intelligence test, personality assessment of the parents, thematic appreciation test, children's appreciation test, Rorschach test, sentence completion test, drawing test, draw a human figure test, three-wish test. These are the various tests psychologically it has been applied. But however commonly used are Rorschach, draw a person test, human figure drawing, family drawing, home drawing, and so forth. Those are projective test has been used. Other psychological tests which have been used is parenting skill assessment, parent-child interaction, child preference, spirituality and morality of the parent, parental alienation syndrome assessment, substance abuse assessment, specific mental illness relating scales have been used. Imagine if one of the parent is suffering from depression, you need to quantify the depression. Such assessments need to be done depending upon the case-by-case basis. However, there are some structured assessment also has been advocated, like Brooklyn perceptual scales, perception of relationship test, custody quotient, Ackerman scales for parent evaluation of custody, parent awareness of skills survey are the important tests have been done. But however, one need to understand about the structured instrument assessment. These scales have never been validated. They have never been compared with the gold standard. They do not have sensitivity, specificity, and also the errors have not been finalized. Rating done and the interpretations are very vague. Peer review articles in the scientific journals are very few. And also these instruments have not been validated for Indian social, cultural, and family background. That means we need to validate those instruments for our setting. And also in India, significant others play a role. That is, father's parents or the mother's parents also play a role in child rearing practices that are not assessed in these instruments. But to summarize the need for psychological test, please remember, custody evaluation is very complex. No single instrument, no single psychological test, or a group of psychological tests will answer the question. Hence, various clinical guidelines, various recommendations have clearly said that clinical assessment, clinical interview, clinical observation, collating information, and the clinical judgment is the gold standard, especially in child custody cases. And with regard to psychological tests, needs to be used only when it is required. Many of them are using IQ test for all. IQ test for the child, IQ test for the father, mother. It's not required. Again, personality assessment of all family members. Again, it will time consuming. If it is required, only has to be done. Even the projective test. We need to use this test as and when required. Should not be applied everywhere. If you are going to apply that, it will be useless and you will be doing wrong recommendation. Hence, the clinical assessment, interview, observation, collating information, and clinical judgment is considered as the gold standard. Now, we will discuss about how to write the custody assessment report. If you are submitting this report to the court, how should the report look and what are the factors you need to cover? First and the foremost, when the custody assessment report is written, demographic details need to be done, hospital number, child's name, parent's name, referral letter, objective of the evaluation, why it was done, starting and completion of the assessment dates, number of sessions, approximate hours spent with the child, parents, collating information done from which are the sources, what is the family assessment of origin, family assessment of procreation, past history, personal history, medical, disability history need to be documented, pre-conflict parental role of child care, that means before the divorce, what was the role played by each parent with regard to taking care of the child temperamental history, clinical interview, observation of the interactions, compliance or resistance for assessment by the parents, father and mother's plan if custody is given to them. How does the mother wants to plan the child custody? How she would like to take care of the child? If it is given to the father, how he would likes to take care of the child? That plan needs to be assessed. Openness of the joint custody, visitation rights, allowing the child to meet the other parents, whether they are open or not. If they are not open, what is the reason they are giving? Whether it is logically explainable or not. Parental strengths, weaknesses. What are the strength of the mother, strengths of the father, weakness of the father, weakness of the mother need to be documented. Further, parental psychopathology, substance use, antisocial personality disorder, domestic violence, criminal cases needs to be documented. Further, is there any parental alienation syndrome? Is there any of the parent trying to do the character assassination of the other parent? That needs to be documented. If there are any psychological assessments are done, IQ, personality assessment, projective tests, sentence completion test, drawing, 3-wish test, child wish. So these needs to be done as and required. In all cases, all these tests are not required. Depending upon the clinical requirement, these tests to be done. Further, you need to collect all the information and you need to interpret the findings. The findings need to be interpreted in the best interest of the child. Further, you need to write the limitation of your reports. Whether your report has all information or else some information is limited or else some of the family members did not cooperate. Further, you need to give recommendations with regard to intervention, treatment of the child or the parents needs to be given. And also, final recommendation with regard to child care has to be written. Further, please keep in mind, do not give verdict. It is the job of the court. You as a mental health professional need to highlight the pros and cons of the custody of the father and mother and the visitation rights if it is given to father or mother. What are the benefits? What are the drawbacks? You need to highlight the points. It is the court which is going to decide. However, for all mental health professionals who are involved in child custody case, a word of caution is very essential. In Western literature, it has been documented many times. Mental health professionals are also dragged into the court when they give this report because the parents are fighting for the child custody. And when the report goes against them, they will give complaint to the professional bodies. If it is a child psychologist, they will give complaint to the Rehabilitation Council of India. If it is a psychiatrist, Medical Council of India. Hence, we need to be very, very professional. And whenever you write a report, it needs to be logically explained. Hence, we have to be very careful. Complaint against the psychiatrist, mental health professionals to the regulatory body is very common. Your report needs to be child-centered, not parent-centered. You need to document both parent strengths and weaknesses. And please acknowledge the limitation of your report. And also interpret your finding based on the evidence and logical reasoning. Please do keep the medical records. And also, recommendation should be child-centered. And the evidence or the report given should withstand the scrutiny of the cross-examination in the court of law. Then only it will be accepted as an evidence. That means just by giving a report, you cannot wash your hand. You need to attend the court. You need to answer all the questions of both the advocates. That means scrutiny of the cross-examination should be withstanding, and you need to acknowledge the limitation even in front of the court. To conclude, my dear friends, please encourage the parents for alternative dispute resolution and ask them to settle this child dispute separately in privacy so that the child is not dragged into the court. Do not attempt for parental alienation syndrome. Adopt a clear custody assessment protocol. Do not yield for shortcut methods. Do not liaison with one of the parent. Don't do that. Maintain good records, especially medical records. Provide a comprehensive recommendations and also report to the court. Educate the parents about the mental health impact of divorce. Way to minimize the impact. Providing the care need to be the priority to the child. You may be recommending, but also you have to tell the parents the child is going through a psychological distress or mental illness and it needs to be addressed before you go to the court. And also, long-term support and follow-up of the child is mandatory because many a time mental health issues may start during the adolescence. That is the time the mental health professional need to act and help the child. Thank you very much for giving your valuable time. Stay safe.